Good morning to our wonderful attendees. My name is Ms. Shalma E. I am an advocate of the High Court of Kenya, and today I am delighted to be the moderator of the day. Welcome to our webinar titled Bits and Pieces of Succession Laws in Kenya. We're delighted to have you today. This webinar was as a result of suggestions from some of our subscribers, so we are honored to honor your request to have this webinar. It's brought to you by ACE Litigator. Just to give you a brief of what ACE Litigator is, ACE Litigator is a legal platform that allows you to access quality legal pleadings. ACE Litigator are also formidable legal consultants, and they also create legal awareness through such training. So we are happy to have you today. You can check out our legal solutions and products through our website, www.acelitigator.com. We are also live on all our social media pages. That is ACE Litigator on Twitter, LinkedIn, and Facebook. So feel free to like, share, and follow. Today, I am delighted to sit across from our wonderful speaker of the day, Ms. Stella Orengo. Stella is an advocate of the High Court of Kenya with 13 years post-admission experience. She has a law degree and a master's in gender and development studies from the University of Nairobi. She's also currently pursuing her LLM from the University of Nairobi. She's an associate member of the Chartered Institute of Arbitrators and a finalist graduate of the Certified Secretarial Studies, awaiting membership into the Institute of Certified Secretaries. Karibu sana, Stella.
Thank you.
So just a few housekeeping rules. This webinar is being recorded for educational purposes. The recording will be available to you after the webinar. You can type in your questions in the chat box and we shall discuss them after the webinar. Also, this webinar will be two parts. The first part will be a discussion where we'll engage our wonderful speaker for about 40 minutes. And then we'll have a Q&A session for 20 minutes. We've also put up a poll at the beginning of the webinar and at the end of the webinar. Feel free to engage and answer our questions so that we may know where you are with regard to succession and inheritance in Kenya. So without further ado, I think we should just go right into it. So Stella, our subscribers are wondering what laws apply to inheritance and succession laws in Kenya.
Okay, thank you, Shalma. Thank you to our viewers and listeners. And we are delighted to host this webinar. Now, when it comes to succession, we have a myriad of laws that apply. Of course, the first one is usually the Constitution, which everyone will knows about the Constitution. And for the Constitution, what it does is it sets out certain principles. One of the principles is the issue of equality and non-discrimination, so that this now translates into even how we distribute the estate or the property of deceased persons. We're supposed to observe principles of equality and not discriminate anyone on any basis. The other principle that the Constitution will set out will be the right to own property, so that if I have property and I pass on, then this property should vest in the rightful owners. So that is the Constitution. Then we have now the Law of Succession Act. And that's now the one that is really the deal breaker in these issues. So the Law of Succession Act will set out the substance of how we deal with the property of a dead person. Then we have rules called the probate rules. They will tell us this is how you go to court, this is how you do this application. So the Law of Succession Act actually is the bedrock of it all. And usually I know the Law of Succession is a very bulky, it's very bulky act. So that's why we do some of these webinars to just break down into pieces, the bits about the law, hoping that eventually as you attend these webinars, you'll get to know what it entails.
Yes, great. Yes. So in addition to the Law of Succession Act, as you've mentioned, the probate and administration rules, the Constitution, are there other laws that apply to succession matters in Kenya?
Yes. We have, as I said, as we began, we have a myriad of laws. there are certain laws that do not look like they really have an impact on succession, but they do. Take, for instance, the Marriage Act, which sets out the types of marriages that we have. So when it comes to succession and how we deal with your property when you're dead, how you marry and the type of marriage will also determine how we distribute your estate. So that if you're married under customary law, which allows polygamy, if you die as a polygamist and without a will, then there's how we distribute your estate. Yes.
All right. That's excellent to know. And also, you've just mentioned customary law. And I'm quite curious on the implication of customary law with regard to succession, especially because we know that the Succession Act is applicable to the commencement date was 1982, thereabouts. So cases that, and we have cases that are 40 years in. So there is a very, very high likelihood that customary law may apply. So could you kindly guide us on how customary law applies to succession matters?
Okay, interesting. I know we are Kenyans, we are Africans, we hold dear to our customary laws. And in as much as we have the Law of Succession Act, which was brought in to consolidate how we deal with issues of succession, and which is a statute that is of universal application. So by it coming into application, it was ousting out the application of customary law. However, there are instances where customary law will be applicable in succession matters. One of them will be for any person who died before the law came into application. So if you died before 1981, 82, and now you're doing your maybe your beneficiaries or dependents are doing succession, then the law that will be applicable to your estate will be the customary law that you're subject to. Yes. Then we have estates of people who profess the Islamic faith. Again, that one is excluded from the application of the Law of Succession Act. There are people who view Islamic law as customary, as their customary law. It's debatable, but that one is excluded. Then we have certain areas. I know nowadays we have counties, but we have certain areas which were predominantly pastoralists. And the land, the agricultural crops, and the livestock in those areas then will be subject to customary law and not the Law of Succession Act. Such areas include areas like West Pokot, Narok, Kajiado, Marsabit. Predominantly, they were pastoralist areas. But now, and this is what our viewers need to maybe get into these discussions. A place like Kajiado or West Pokot was then a pastoralist area. Now things have changed. Should we still be having this particular provision in the act, or we need to amend? And these are some of the things we usually encourage our viewers when you interact with the law and these issues. Just suggest amendments to the act to improve our laws. Yes.
Okay, excellent, excellent. And just to demystify one of the things that I hear a lot, especially when it comes to inheritance, the issue of gender. And I mean, we are a bit more progressive these days. So it's difficult, or it's very difficult to hear that someone has been disinherited because of their gender, but it happens. And the biggest excuse is normally that this person passed away before 1982, the commencement of the Law of Succession Act. So what would you advise, or what is your experience with regard to that?
Okay. So now, let's bring it live. Let me use, my grandfather has passed on. So let me say my grandfather, let me see, he passed on before the act came into application. And maybe my aunts and uncles started succession after the act now came into application. So when you look at the act in its plain reading, then it will be that the customary law that my grandfather's estate, the customary law that my grandfather was subject to,
yes,
will be the one applicable.
yes.
If you come to my community, in terms of succession, customary law will not allow a woman to inherit, and especially a married woman. What are you coming to inherit? And you have your own place.
Yes.
So then, if this comes to court, then you'll see that if we proceed under that customary law, there's a lot of inequality and a lot of oppression on women.
Yeah.
So what courts have done is, in that particular provision, it says, as much as we proceed under that customary law, we try as much as possible to comply with the act. So what courts have looked at is what will serve the ends of justice. Will it be to allow that customary law to disinherit these women, or can we tweak it a bit to allow these women to inherit? So, and then remember also that in as much as our courts are allowed by the Judicature Act to apply customary law, that customary law must not be repugnant to justice and morality. Wow. So where it is going against justice and morality, we depart from that and apply what is right.
Okay, excellent. Excellent to know that the courts are sensitive to inheritance issues and that someone cannot be disinherited because of their gender. That is great to know. Also, our subscribers have been wondering, people have very many different types of properties. Some have shares in companies, some have land, some have apartments. Others are, members of circles and they have savings. They even have their own social chamas at home. Some have taken life insurances. So are there types of properties that go through the succession process and some that don't?
Yeah, a good question. And this question you're asking has been has formed one of the myths that has brought a lot of conflict in families when they are doing succession. So what is important to do is to understand that, one, not all property can come under succession. We have property that forms the estate of the dead person that can go through succession. And then we have property that cannot go through succession. And I'll point out three instances. Married women, married men. This is for you. So you are married and then you decide to buy this house or to buy this plot of land and own it jointly. So if your husband dies, that property does not go to the estate of your husband. It automatically becomes yours, the surviving spouse. So that one cannot be taken through succession. So for our viewers, when you're dealing with your relatives and friends, tell them to stop antagonizing widows and widowers who have been owning property jointly and telling them, no, that property belongs to our sister or our brother. No, it is not there for succession. Okay. Then we have property which you have nominated a beneficiary. And I've seen these, if you're members of, I think, circles, and you'll always be told as you invest here, please tell us who your nominees are. Okay. So you will say my mother, my father, my cousin. So that one again is not available for succession. When you pass on, when these people are notified and they bring the requisite documentation, that property will pass to them in the shares you nominated. The other one is gifts. Okay. Gifts, and we Africans again, we love gifting. A gift, let me put it in a very simple manner. So your grandfather calls you and tells you, no, you've been one of my best grandchildren. I want to give you that particular piece of property for you to own. And so you're told that is your piece. Then you take steps, between you and your grandfather, take steps and have that property now transferred to your name. If your grandfather passes on, and that property will not be available to be dealt with under succession. Okay. Yes.
So to our viewers, of course, those are excellent ways to avoid court.
Yes.
So for married couples, they can opt to join properties jointly, and then the principle of survivorship.
Yes.
And remember also to update your nominee forms in your circles and your life insurances, because clearly these people are receive benefit now at the announcement that maybe you've passed on. These people receive benefit according to what you have indicated in the nominee form. And here we've talked about deed of gifts, which are basically transfers. So I'm so curious to know, because many people actually have this issue that my father gave me this parcel of land. Even during his lifetime, he told me to till on it. He told me to, it's mine. And they deem it as a gift. So is it a proper gift in law, or are there legal procedures that have to be undertaken for that to be considered a deed of gift once the patriarch or matriarch of the family passes on?
So now, good. When you're gifted a particular property, you must ensure that that property, you go through the processes that are required to make that property legally yours. If it's land, ensure that you've gone through the transfer process, obtain the consents registered, and have title in your name. If that does not happen and this person dies, that property still forms part of the estate of the deceased person, and it will be dealt with under succession.
Okay.
Yes.
Okay, so you had it here. So if you've been gifted a parcel of land, then make sure that all the legal procedures are taken and the parcel of land is transferred to you, so that you have a title deed in your name, and that will form a proper deed of gift under succession law.
A dependent will basically be anyone who is being maintained by you financially. Okay. And in the Law of Succession Act, we have a whole list. And dependents come in, especially when we are dealing with issues of someone has died without a will. How do we tell who the dependent is? Yes. Or if you've died with a will but have left out someone, then if this person feels they were dependents, they will make application. So now we'll have to look at, are they really dependents or not? But the law has said who a dependent is and has given a classes of dependents. Okay. Yes.
So could you kindly tell us these classes of dependents?
So one will be, let's say you're married. If you're married, it will be, of course, your children, your spouse, or former spouses, or separated spouses. Again, here, let's be clear that if you married X, separated, married Y, but still you're maintaining X for some reason, she is your dependent. Okay. She's your dependent. Then your siblings, your half-siblings will also be dependents. Your mother, your parents are also dependents.
Okay, just for clarity purposes, you've mentioned something to do with maintenance. So is it that there are certain dependents that can inherit from your estate, whether or not you are maintaining them, just by virtue of them being, your family? Or and then are there dependents that for them to inherit, they have to be maintained by you?
Yes. So your children, your spouse, those ones as of right, even your parents as of right, they'll inherit from you. Yeah. Then we have those ones like if again in Africa, we don't really do adoptions a lot because we believe in just this is my cousin's daughter, let me just take them in. Yes. So these are children you've taken in and you've been taking care of them. So they're not really your children, but you've been taking care of them. So they still are entitled to inherit as dependents.
Okay.
Yes.
And I'm aware that 17th November 2021, we tried to pass a bill.
Yes.
And it's very interesting to see that some of the suggestions that were made to the bill did not pass, because I think the only amendment that was done was the definition of spouse.
Yes.
So just to take you back a bit, is there a difference between a dependent husband and a dependent wife?
Now, interesting. Let's go back to that amendment because it has been, it has brought a lot of confusion.
Yes.
When you look at the Law of Succession Act, a husband has never been listed as a dependent.
Mm.
Yeah. So it was just the children, the wives. So the husband was not there. The husband was supposed to prove that they have been maintained by the wife prior to her death for them to qualify as dependents. I know when we talk about gender equality, we usually look at women, sorry.
Exactly.
But the men also felt like this particular provision was very oppressive to them. So that is what informed some of those amendments. Unfortunately, all those other amendments were dropped. The only one that was maintained was the one bringing husband under the definition of a spouse. So has it changed anything about a husband trying to prove? That was the intention with the bill, but it has not changed anything. As a husband, when your wife passes on, you need to prove that you're being maintained prior to her death.
Okay, so for clarity purposes for our attendees, for wives, former wives and children, they really don't need to prove that they were being maintained. By virtue of them being a wife child, they are entitled to inherit from you. And then for husbands, unfortunate for them, they have to prove that they were being maintained by their wife immediately prior to her death. So by maintenance, Stella means that like for your mother, for example, who will maybe your grandparent, you send them money for something. That is what you call maintenance. Exactly. So for husband, they have to prove that there was some kind of financial assistance from their wife, which is interesting. And just to look at the recent Ripples International case, because Ripples International is actually an organization that champions women's rights. And based on that case, there were a few amendments. It is quite disheartening to see that some sections of the Law of Succession Act were declared unconstitutional and some were not. So I will discuss that in a few minutes to come. We definitely want to hear your views on that specific case. So, but first we want to know this issue of entitlement to the estate and where I feel like I have been left out of my father's will. And why I mention this is, you could have a parent that is sick and there were maybe one sibling did the most to take care of this parent and you did not. So you're left a small portion of the estate or you are not. Your parent just opts to leave you out of the will. So in that case, now that you've mentioned that children are dependents, whether or not they were being maintained, how does that work?
Okay, so when it comes to wills, there's something we call testamentary freedom.
Okay.
So that is the freedom for me to dispose, to bequeath my property to whoever I want. But that freedom should be exercised within the limits of legality and what is appropriate. So that I will not today write a will and say, take the proceeds of my net estate and burn and liquidate it and burn that money. That is illegal. That will not take effect. But do I have a right to bequeath some of my children property and leave out one? Yes. For example, if I was unwell and this particular child is the one who's actually driven me to my sickness, and I just feel like they should not inherit, then I can leave them out of my will. Or I decide I have provided for these children and they're at a good place, and I still have younger ones who still need more. So I may give the younger ones more in my will, and maybe these ones who are already established, give them something little. Again, it's within my rights. Now, if someone feels they've been left out of my will, of your will, they can always go to court and do an application for reasonable provision. Yes. So, Either they're saying they've been totally left out of your will, or they were not adequately provided for in the will.
Okay.
So when they go to court, remember we said testamentary freedom, that freedom for me to distribute my property in my will the way I want, as long as it's within the legal confines. Courts will not interfere with that freedom, but they will look at the circumstances and see why didn't the maker of the will provide for this particular person? What was the relationship? Where are the other beneficiaries as compared to these particular ones? So there are so many other considerations they look at to make a judgment on whether to make provision for that particular person.
Okay.
And when they do that, they will not invalidate the will. They just make a small provision for the person. Yes.
Okay, excellent to know. Wow. So now, I really don't have anything useful to add. I think you have really explained it very, very well. So I will just take you next to our next question, which is on the difference between testacy and intestacy. And first, let's start with testacy. Very, very briefly, just tell our attendees today what people mean by testacy succession. Very, very briefly.
So testate succession, you die with a valid will in place.
Okay.
A valid will being a legal document that expresses your wishes on how your estate and affairs should be dealt with after your death.
Okay.
Yes.
Great. So tell us, what do you mean by valid will? Are there certain things that we have to do to ensure the validity of that will is in place?
Okay.
Talk to us about the types of wills and what legal requirements we need to meet to ensure that these documents are valid.
Okay. So types of wills. No, wills are strange to us, but we encourage people to write wills. We have two types of wills. We have the oral will and a written will.
Okay.
I think oral will, we are more familiar with it because that's what happens, though it not in the legal, doesn't meet the legal requirements.
Okay.
So for you to do a will, there are two requirements. We look at the legal requirements and we look at your capacity. So when it comes to capacity, one, you must be over 18 years and above, so you must be an adult.
Okay.
So a child can never write a will.
Okay.
Then secondly, you must be a person of sound mind, able to understand that what I'm doing is doing a will. These are my beneficiaries, this is my property. So if you have a mental illness or you're not able to understand that, then you do not have that capacity to do a will.
Okay.
So that goes into capacity. Then we have legal requirements. If you come to legal requirements for oral wills, one, you must make it before 2 or more competent witnesses. Then secondly, you must ensure, okay, no, sorry, not ensure, and I'll address this issue about oral wills. For it to take effect, you must die within 3 months of the date of making that oral will.
Yes.
Now, the thing I wanted to address about oral wills, please do not go killing people because they've made oral wills and they're not dying within the 3 months.
Gosh, yes.
Window period.
That would be quite unfortunate.
Yes. Then, so said about the competent witnesses, then you must ensure that it's not ensuring, you must die, for it to take effect, you must die within 3 months of making the oral will.
Okay.
Yes.
All right. Are there specific oral wills that do not need to meet those formal requirements?
Yes. Now, there are persons working in the armed forces and merchant marine. You know the nature of their work. Like I can make a will today, an oral will, and then I'm deployed somewhere for an assignment.
Yes.
So for those ones, if they die beyond the 3 months, their oral will still be valid because of the nature of their work.
Okay, and what about written wills? So what are the legal requirements that have to be made about written wills? And actually, before you answer that question, very curious to know, one of our subscribers asked a very interesting question. So what happens when someone records themselves and they do a video recording of themselves saying, you know, how they want their estate to be distributed? and goes to coma, you know, and for like a period of 2 years, you know, they have not, you know, met the threshold, but tell us, or even doesn't, you know, can that recording be considered a valid will?
Okay, so again, we will go back to what are the, these are emerging issues,
Yes.
but we will go back to what does the law say about a will? So one, has it met the competence test? Are you competent? Are you above 18? And are you of sound mind? Then we go to now the legal requirements.
Yes.
Yeah. Was there someone to witness, two competent witnesses? Yeah. So we will always look at these emerging issues against what the law provides.
Okay.
Yes, yes.
So talk to us about written wills very briefly.
Written wills, one again, the issue of capacity, 18 years and above, and then be of sound mind, have that understanding. Those are the capacity requirements. The legal requirements, one, you must, when now you, let me say now person X is doing their will, maybe they have written it, it must be witnessed by two competent witnesses.
Okay.
Usually guard against having the beneficiaries also as your witnesses. Otherwise, if they are witnesses, then they need their signatures to be witnessed by other independent persons.
Yes,
yeah.
yes.
Then, again for wills, as you put your signature on that document, put your signature in a way that you
to show intention.
Yes, you intended that this is my will.
Yes.
So if I write a will and then I go and make a mark, a tick somewhere, we will be left wondering, did you really want that to be construed as a will?
Yes, yes.
Then we have instances where maybe I am so unwell or I'm not able to write. So I come and tell someone, please write, give Stella this, that. Then sign. So you can actually direct someone to do a will for you.
Okay.
Yeah.
Yes.
You can direct someone to do a will for you, and when the witnesses are coming, you tell them, actually, I'm the one who directed my advocate to do that will. Or you say, if they were not there, you say, I directed them. This is my signature. I acknowledge this is my signature. So that is also something, because at times we find ourselves in situations where you're not able to do it. You can direct someone to do it.
Okay.
Yes.
Okay. You've heard it here. A will, a written will, which is best practice, of course. Just write a written will. Don't leave an oral will. Is a legal document. So make sure that you consult us at ACE Litigator, and we'll be able to guide you on these formal requirements that need to be met for you to create a valid written will. So we'll just dive into intestacy. Very curious, because 80% of our cases in court are actually based on intestacy.
Yes.
Why? Because people actually think that when you're writing a will, it's like you're signing your death sentence. I've actually interacted with a client before who thought that once they write their will, they have relinquished control of all their property. So they were very, very scared to write the will even from the beginning. So talk to us about intestacy, and especially tie it in with the Ripples case and what was declared unconstitutional. And also the issue of life interest, very briefly.
Okay, good. So intestacy, which is what we are familiar with, is you die and you have no will, or you left a will, but then remember those requirements you said on competency and validity?
Yes.
That will does not meet that test. So again, your estate will be dealt with under intestacy. Or you left a will, it got lost, it can't be found, no one knows the contents. Again, so we deal with you as an intestate. So the Law of Succession Act has envisioned several scenarios where someone has died without a will. And we will consider them as follows, and I hope our viewers will be able to follow. Let me use, let me say Peter. Peter is married to Mary. Peter dies and leaves Mary with no children. So what happens, and he's died without a will. So this is what will happen. Mary will get all the household and personal effects Absolutely. So all those household and personal effects belong to Mary. And then they look at 10,000 or 20% of the net estate. When I talk about net estate, it is that Peter has died, we have done succession, we have paid all the debts. What remains is the net estate. So Mary will get 10,000 or 20% of the net estate.
Okay.
Then the remainder, once we remove the household personal, the 10,000 or 20%, the remainder, she has a life interest in the remainder. Okay. I will explain about life interest later on. Yes. Now let's come to now Peter has died, has left Mary with one child or several children. Again, Mary gets the household and personal effects. Then again, the 10,000 or 20%. And then the remainder, she has a life interest in it. So that is a widow, a spouse has been a surviving spouse and children or a child. Now, the other scenario is Peter never married.
Yes.
No children.
No children, yes.
So this is what happens. His estate, this is how now, this is the order of how people get to inherit. We start with the father. If the father is not alive, the mother. If the mother is not there, then we go to the siblings and their children. If the siblings, if that category is not there, we go to the half siblings and their children. If that category is not there, we go to the relatives. And relatives, we go up to the 6th degree. So I don't, you know the way you say my first cousin, second, yes, up to the 6th.
Yes.
If that whole group is not there, then the Kenyan government will be very happy to say, pay the net estate into the consolidated funds. Yes.
So just to clarify now, with regard to the Ripples case and this women's group, they were very, very intentional on declaring some certain sections of the whole procedure of intestacy. That is when someone passes on, leaves a wife and children, and when someone passes on, leaves a wife by themselves, and when someone passes on, leaving just you know, no wife, no children.
Yes.
So there are some certain sections that have been declared unconstitutional. Maybe you can discuss that.
So now, for us to discuss that, let's put the issue of life interest in context.
Yes.
So when you pass on and your spouse gets a life interest, it means they are not the absolute owners of that property. They're just allowed to use that property for their lifetime. They are always holding it in trust for someone else, either the children or whoever, So now, this life interest, in case your surviving the wife dies, it ceases, it terminates, or if they remarry. So it was, I personally also think it was very discriminatory because it does not apply to men. Because if a wife dies and they leave the husband with that life interest, if they remarry, the law does not say anything about that life interest terminating. So the Ripple's case was questioning that bit, that discriminatory bit about life interest terminating for women upon remarriage.
Yes.
So that particular section was declared unconstitutional. Then on the issue of, we said Peter didn't leave a wife or a child, so I've outlined the order of so you see, we start with the father. If the father is not there, the mother. Again, we were questioning, so why should we start with the father? So again, that whole section was also declared unconstitutional. I hope the lawmakers, the people concerned will do the necessary changes to just reflect what the court said about those provisions.
And also to reflect the current economy, because you have said that, a wife is entitled to shillings 10,000.
Yeah.
I mean, to reflect the current economy. But of course, there are households that is a reality, and it's sad, and we hope the government is doing something about it.
Yes.
So we are a bit short of time, so we'll have to go through the next questions quite quickly. Some of these questions, of course, that we won't be able to answer will be available after the webinar. We will do a short post that will have all these questions and the answers, so rest assured that all questions will be answered by the end of the webinar. So we are curious on what steps and documents are required to apply. Now, we've talked about wills, we've talked about, the issue of succession without wills, we've talked about intestacy, but what happens when now we are tasked to apply for the probate and administration processes, to now go to court and get this grant? So could you kindly tell us the documents that we require? Because I feel like the documents, especially the supportive documents, are what we require, we need to know, and also talk to us about this fighting over dead bodies, because we've seen so many people fight over dead bodies, and why do they fight over dead bodies? So clarify to us the supporting documents and why we don't need to fight over dead bodies.
Okay, thank you. Now, interesting about the fight over dead bodies.
Yes.
But we have forms. We have forms already in the Act. But I know usually people have a problem with, feeding information into the forms. We said as litigator has a dedicated platform of pleadings, and these forms also form part of the pleadings. You can always check our site, come onto our site, and you'll get the forms, the ones you require to make this application. Okay. Now let's go to the supporting documents.
Yes.
So when you're applying for any succession matter, what you need is you need a copy of the death certificate of the deceased person, certified. Then birth certificates for dependents who are below the age of 18. For adults, we need the copies of their IDs. For spouses, marriage certificate. And then there's something called the chief's original letter from the chief. Good people, please make a point of knowing who your chief is, who your nyumba kumi is. They are very important in the process of succession.
Yes.
They're the ones who will say, truly, so and so died, left this wife and these children, and this is their property.
Yes.
So now, why people fight to bury?
Yes.
There's this notion that if you bury, then you own, you get to own the property of the dead person.
Yes.
But that's not really it. You see, when you bury someone, you get the burial permit.
Yes.
With the burial permit, using their plus their ID, then you can get the death certificate. Right. And you see, the death certificate is a very pertinent document when you're applying for succession. So please, stop fighting about dead bodies. In fact, there's a case that said there's no property in a dead body. Yes. But at least we understand why you're fighting, so that you can get that burial permit and get the death certificate.
Okay.
Yes, yes.
Okay. Oh, thank you so much, Stella, for this session. I'm sure that our attendees have been able to get some clarification on some of the issues that they had raised through our various platforms. And I just want to delve into the questions that some of our attendees have asked. Okay. So we have a few questions. We will deal with some of them due to time, and the rest we will have a post that will go up that will answer all the rest of the questions. So make sure you check our social media platforms, and just as Stella has said, for the documents that you need to require to apply for a grant of probate or a grant of letters of administration, go to www.acelitigator.com. Those documents have been prepared by formidable legal professionals, so they are ready for your use. Stella, so the first question is, if a deceased person was married in church and had children and went through separation 30 years ago, and then later remarried under customary law, so and had children through this union, how will this estate be shared between the families in the absence of a written will?
Okay, just clarify that the deceased person separated, they did not divorce.
Yes. The key word here is separated and then married under customary law, so rorashos took place. And then now this person they were blessed with children in the second union. So there are children in the first union and children in the second union. So they're curious to know how this property will be distributed in the absence of a will.
Well, that's a very nice question. It actually paints the picture of our society.
Yes.
Now, one thing we need to understand is that even before the Marriage Act was amended now not amended, we did an overhaul. No Succession Act recognizes polygamy only when the person is dead. Yeah? And so in this situation, even that wife who was married through Rorasho is a wife for purposes of succession.
Okay.
And their children get to inherit. This other one, those separation but no divorce, so she's still a wife.
Yes.
So we will take all these wife A, church, and the wife customary, and their children, and all of them have a right to inherit from the estate. Let me address something that has been happening. I have been meeting it very often, that you marry person A, you kosana, separate, then you go and marry someone else, customarily, you start divorce with this person A, you die before divorce is over.
Yes.
She's still a wife.
Yes.
She's still a wife. So I've seen so many fights around that. She's still a wife. So ensure when you're doing your divorce, please bring it to completion.
Yes.
Yes.
Okay, so in the event that maybe the first marriage had 4 children and the second marriage had 2 children, so the Christian marriage has 4 children and the second marriage has 2 children, how will these assets be distributed?
Good. So Christian marriage, 4 children, we take the 4 children and we take the 2 children from the customary marriage, those are 6.
Yes.
Then we add wife from Christian marriage, those are 7. And the customary wife, those are 8.
Yes.
So all these 8, if the estate is 1 million, we divide 1 million by 8 so that each person is a unit getting equally from the estate. Yes.
Okay, I think that is pretty clear. And of course, Section 40 of the Law of Succession Act is also clear that these properties are distributed to the family in units.
Yes.
So we have another question on the issue of signatures on wills. So this is a very interesting question because it talks about electronic signatures and whether electronic signatures make wills legally valid or they have to be still fixated on having physical signatures. And I just want to answer this question practically, because you see the witnesses need to be present, everyone needs to be present. So talk to us about electronic signatures and if they, of course, make wills valid.
Okay, again, the issue of electronic signatures, those are emerging issues which we need to deal with as practitioners because it's a reality. But let's go back to signatures. If I do a will and I have 2 witnesses, the law says the 2 witnesses need not be there to see me signing.
Yes.
But every witness must be there to sign, to see, like, okay, we don't need all the 2 to be there together.
Yes.
So I can have my sister come and witness my signature, and then my brother who is in Mombasa can come tomorrow and witness.
Yes.
So the one in Mombasa will not see me signing, but I'm allowed to tell him, you know what, this is my will. This is my signature. I acknowledge this is my signature. So you sign for me. Now, the problem with electronic signatures, how do we even, first of all, how do we prove that it is your signature and the intention? It may be yours, but what if I have access to your signature and I write a will and then superimpose that e-signature on it? Remember the issue of intention, placing a signature in a way that I intended for this to take effect as a will. So those are some of the issues. So for me, I will not encourage anyone to do the e-signatures for now. until maybe we look at the law and amend it and make provisions for it.
And I think also there is a very big confusion when it comes to electronic signatures, because people believe that I sign a document, I take a picture, that's an electronic signature. It actually isn't, and it has to be registered, and you have to even have a certificate number. And currently, I don't think there are many electronic signatures that have been signed. I honestly don't even think this has been rolled out. So there is a practicality issue here, and also the fact that witnesses have to see you sign that will, you know. So it's bringing in the issue of signing remotely, but honestly, practically speaking, maybe amendments will be made in recent times to accommodate how the world is changing. But as it currently stands, of course, it's not practical. So it's better to just sign your documents physically. One of our viewers is asking about gifts in contemplation of death. I think we've had this discussion before, and the practicality of gifts in contemplation of death, especially in the Kenyan context and case law. So they are asking, first of all, maybe you can discuss gifts in contemplation of death, because according to our act, these are properties that can be inherited without going through the succession process. And what happens if now the person who's donated this gift survives the person who's been gifted? Does this gift go back to, you know, the owner? Talk to us about the practicality, because I feel like sometimes the law says something, but the practical bit of it, you know, just help us understand.
Okay. Before I delve into that, I just got a question, which I think it's a burning one. Let me address it. That that if someone dies and leaves children only, so our Peter has died, hasn't left a spouse, has left children, what happens to their property? Let me just address that, because it looks like a very burning and issue. So what will happen is, if the children are adults, they're entitled to the estate of their father. If they are not of age, whoever is doing the administration will administer the estate and then hold that property in trust for these children until they get to the age where they are able to own. So now what is happening, and which is the reason why we have a lot of children left destitute, is that the administrator or the person holding this property in trust is wants to deal with the property as though they own the property, to the extent of disinheriting the children. That is wrong, that is punishable, and we're encouraging, and this is the reason why we encourage parents. We don't know about tomorrow. We encourage parents to, as much as you're writing wills, please appoint guardians for your children. Talk to these guardians, agree with them. You can always tell, if I left my children in the care of this brother of mine, things will, no. But this cousin is able to take care of my children, is able to take care of my estate. So please make it a point of doing those appointments of guardians. You can even appoint guardians in your will, or you can do separate guardianship documents, which again, we have them on our platform, where you say, so-and-so will be guardian of my children in case I pass on. If maybe the two parents are not living together, you can always agree with the other parent. You propose a guardian, I propose a guardian, we have a document, and keep on checking and reviewing that guardianship document. If your guardians predecease you, then you have reasons to change. Yes. Now, back to gifts in contemplation of death. The practicality, as you said, it's, how do I put it? It's not a situation I have dealt with a lot, because what is the right language to use?
I feel like it's very difficult to prove. Because the law says that you're given car keys, and then, or something to show that, you know, that you have gotten this gift, or you're given a title deed to show that you've gotten this gift. I honestly think that, of course, the law says that it's possible, and the law says that you can get this gift in contemplation of death. I think there's not much case law on it. Maybe we will do a little bit or more research on that one, and maybe engage our viewers. But the best practice dictates that just have the gift transferred to you. I think that is the easiest, most sure way of ensuring that this gift is yours. And of course, the law also says that if the donee passes on and leaves, the donor, then of course, I mean, the title document says, or the logbook says that it's still his. So it will definitely go through the succession process after that.
I think that the only time I have dealt with gifts in contemplation of death is someone was questioning whether this person was even in their right frame to know if they are donating, if they are giving this gift. And it was a very, I know now we are dealing with a lot of religious brainwashing, and it was a situation where someone thought, if I do this, then I'm able to go to heaven, all that. So that's the only instance I've dealt with it. I would like to maybe ask our viewers to give us instances where they have dealt with such issues. But for them, then it was very hard to prove that, to even actualize that gift.
Okay.
Yes.
Okay, thank you so much, Stella. The last question, and of course, we've received so many questions, so the questions that we will not answer during the webinar will be answered through a post, or we'll actually have to do, we'll do a paper on it and have all these frequently asked questions, and just be on the lookout through our sites, all our social media platforms, that is on Twitter, LinkedIn, and Facebook for this paper. So the last question, which I think is very important, and I will just bring it up real quickly, is the issue of marriage and wills. So our viewers are curious to know what happens when, if I've written a will as a single person and then I marry, or I have written a will and then I remarry. So of course we've discussed that our laws allow for, especially customary law, they allow for polygamy. So what happens when I keep on remarrying? What happens to my will?
So you're allowed to, in fact, best practice, you've written a will, keep on looking at your will, reviewing, revoke, and do a new one.
Yes.
That is a practice, I think, which we need to do more often. So then it will take care of these issues of the wives.
Yes.
Wives coming in.
Yes.
I forget even about wives. You write a will today and you have 3 children.
Yes.
And then 1 year down the line, you have another child. What happens? Again, go look at your will, revoke the previous one, and do a new one. Yeah.
Yes.
There are people who opt to do what we call codicils.
Yes.
But then you'll have so many, okay, though recognized in law.
Yes.
They are recognized in law. But then again, for good order and practice, just review your will, revoke this one, and do another one.
Yes.
Now, tied to that, there's the issue of that I wrote a will, and I had wife A and children for wife A. Then I marry someone else, customary, get children, wives. But this will now, I die having not included, provided for these. So these other ones can go to court. Remember the reasonable provision? They can go to court and ask to be reasonably provided for. Another scenario will be, I have a will, I have written my will, but then I left out some property. What happens? We will deal with the property in the will as per the will, testacy. What has been left out, we will deal as the estate of an intestate. So that's why we encourage, please don't write wills on your own. Look for a lawyer. They're able to tell you, there's a clause called the residual property clause. They're able to put that in your will to take care of this other property that comes in.
Okay.
Yes.
Okay, thank you so much. And as you've said, of course, very important for you, if you have a will, to keep on updating your will so that it can be valid. The law is very clear. There's actually a revocation by law and revocation by intention through distraction. And by law, if you marry, then your will is automatically revoked. So it's very, very important for you to keep on updating your will. As mentioned, ACE Litigator has the top legal consultants on this area of law. So please feel free to engage us, and so that we can help you to review your will if you have a current will, or even to write a will so that you ensure that you take care of your loved ones. It's literally the best gift that you can give to your family to ensure that the process is as seamless as possible. Thank you so much, Stella. I believe that we've had a very engaging webinar today. And yes, I thank you so much for taking the time to join us today and to demystify some of these myths that we've been hearing on succession laws. To our attendees, feel free to engage us on our social media platforms in case you want us to have a webinar on the same topic, related topic, or even a different area of law. We have a team of legal experts that are able to give these legal trainings, and we'll be happy, of course, to engage you. And before we leave, I cannot leave until we discuss this wonderful feature that ACE Litigator has come up with. Stella can tell us more about that.
Okay, thank you. So as we started the webinar, we talked about ACE Litigator, and what we are mindful of is access to justice. So whatever products, whatever we do, at the back of our mind is to enable you have access to justice. Now we realized as a group of lawyers that there's a gap in the market. When you as a kawaida mwananchi wants to get a lawyer, you have to ask someone for a referral, you have to Google, and do all that. And at times you end up in the hands of masqueraders. So this is what we have done as ACE Litigator. We have a product called Dial a Lawyer, where we list advocates on our platform, and we list them by areas of practice and for Kenya counties, so that if you want a lawyer who's practicing succession law, for example, you key in succession law, it will bring you all the advocates, and by town. If you're in Migori, for example, you'll be able to see who is in Migori and get to them. What we do is we go through a stringent process of vetting these advocates before they sign up. We check with LSK and get documents just to prove that they are legit lawyers. So you'll see that the listing platform, the listing solution in our social media. Please patronize our pages and use that feature to help you in your journey for access for justice. Thank you.
Okay, thank you, Stella. And of course, during the webinar, we talked to you about our polls, and I hope you had a chance to engage us on our polls. And yes, actually, our team is, because of the many questions that we've gotten, we actually have to have this webinar again. So be on the lookout for the link or when we'll have our next webinar. And also make sure you visit our social media pages to see how people engage with the polls, your fellow attendees are engaged with the polls. We thank you so much for engaging us today. We are honored and delighted that you are able to honor our invite and register for the event. Please be on the lookout for the next webinar, and we wish you a fantastic day.